You're listening to an Airwave Media Podcast.
Where, I ask, she says, have the people gone, and what has become of their powers? What a job, right? You're just a bank cashier. You're minding accounts. You're handling people's deposits, making sure everything on the ledger adds up. It's not your money in the bank. Not most of it. And then suddenly, you're the one who gets sued by the state, and the case is taken all the way to the Supreme Court. And your name is on one of the most important Supreme Court cases in the United States history.
Now's the time to save on new carpet at the Home Depot. Receive 10% off your total carpet project and 12 months special financing. Plus, we'll measure your space for free. Choose from a variety of stylish, on-trend options fit for everyday life. With LifeProof with pet-proof technology, Home Decorators Collection, and Traffic Master carpets. Save 10% and get 12 months special financing now at the Home Depot. Offer valid April 16th through May 3rd, 2026. Exclusions apply. For licenses, see homedepot.com/license numbers.
That's James McCulloch. That's what happens to him. He's not a politician. He's not a famous lawyer. He's just a guy at the desk at the bank when the state of Maryland tries to tax that bank. And because he doesn't have any policy on record to pay Maryland a tax, he says no. Well, the Second Bank of the United States was a controversial institution from the start. It had been created in the early beginnings of the American Republic. Alexander Hamilton is part of that. And then it was closed down and it was reopened after the War of 1812 and 1818 when they needed money. This is how it works. The Second Bank of the United States was owned by was controlled by private stockholders, but it was the depository for federal funds. And what they did is say, well, this is our agreement with the federal government. We'll deposit your funds. We'll also loan you money as a government. But we're not paying any taxes. And it issues notes that are prized. They're treated like money throughout the United States at this time. State banks begin to fail in the Depression of 1818. And they blame their troubles on the federal bank. They don't have to pay taxes. They get all the federal funds from all of us. So Maryland imposes a hefty tax on any bank not chartered within the state. The Bank of the United States was the only bank that fit that category. A state court rules for Maryland, and the Maryland Court of Appeals affirms it. Looks like they're going to have to pay. They take it to the Supreme Court of the United States, reviews the case in 1819. Enter John Marshall, Chief Justice of the United States. He understands the stakes immediately. This isn't just about a bank cashier. The Constitution doesn't say Congress can create a bank. Maryland's saying there's no explicit authority in the Constitution to have a bank. John Marshall reads the Constitution differently. He points to the necessary and proper clause and argues that the Constitution is meant to function, not just exist. You don't create a national government and make it weak. The whole project of the Constitution was not to make it weak. It has to function. And the Constitution authorizes Congress to do what's necessary and proper. If Congress has powers like taxation, borrowing, these are money powers. They suggest banking. If they can regulate commerce, that's related to banking too. Creating a bank is a very reasonable way to carry those powers out. You're going to collect fines and put them what? Nowhere? So Marshall hands down his decision, and it opens the door to an idea of implied powers. The federal government isn't limited to a checklist. It doesn't just have what's written in there. It needs the tools that it needs to do its job. That's foremost. Marshall frames it simply but powerfully. If the end is legitimate, the means can be constitutional. In one stroke, the court gives the national government room to grow and adapt. Now let's qualify this, because we're probably going to start to freak out here. Like, how does this bank have all this power on its own? Well, it doesn't have it on its own. Congress creates the bank. Just to be clear, the federal government creates the bank. The only question is whether that action of Congress has to be thrown out. And the court in its history, although it's John Marshall that establishes that the Supreme Court can do judicial review, and after a law is passed, if it's unconstitutional, throw it out, make it void, make it unenforceable. It's not extremely common. It does happen. Maryland state tax cannot stand. States cannot tax federal institutions. The power to tax is the power to destroy. If Maryland can tax the bank, it can tax it into oblivion. That means it's reducing what a federal power can be. So McCulloch never does pay that tax. Maryland does back down. The ruling establishes a lasting principle. The second bank of the United States will be around for another 20 years. Then Jackson gets rid of it. Federal law is supreme within its sphere, and the Constitution is flexible enough to support a working national government. And sometimes, a lot of times, they're going to be operating in the same territory. So Maryland is a place that Maryland runs, and Maryland is a place that the federal government, that the whole nation has decided to put a bank branch. That's what we're going to talk about today, because in his decision, John Marshall leans heavily on the power of the people, that concept. We the people. And he says the Constitution was ordained by the American people collectively. It's right there in the preamble. Not by the states as separate sovereigns. Federal powers, once granted, are supreme within their sphere and cannot be controlled by individual states. In a previous episode on the 10th Amendment, I went over the 10th Amendment. The 10th Amendment is very short. It simply reads, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people." So today we're going to talk about something slightly different. The last episode we talked about the general discussion you usually have about the 10th Amendment, how it's this source of state sovereignty, and people, during the civil rights era, the bad use of it was for preventing progress on civil rights, keeping kids out of school because of the color of their skin, and asserting states' rights, the 10th Amendment. And it has the function. And today we wanted to focus on those last four words that are rarely talked about, or to the people. Because it's not just about states. The powers not delegated to the United States by the Constitution are reserved to the states respectively, or to the people. So there is a line in there in the 10th that actually limits states, because if there's something that the states cannot do that are prohibited in the Constitution, the 10th is limiting that as well. Here, what's an example of that? Custom taxes, only collected by the United States. So the 10th actually limits states a little there too, or at least clarifies it. As we discussed in the last episode about 10th Amendment, what's the use? We think that mostly the 10th, and this is true of the 9th as well, these amendments are just kind of road guides, maps for legal interpretation of how you're supposed to look at the Constitution. There's been very little on the 10th Amendment, just a bit. And more recently, you've seen some action on the 10th Amendment, particularly with the more conservative justices on the court, in decisions limiting the ability of the federal government to overuse the Commerce Clause. Like, you can't use the Commerce Clause, they say, to regulate guns near schools. It's a worthy goal, some of the justices say. It's a worthy goal. That's not what we're talking about when we debate Supreme Court cases. You can't use, the federal government can't say, I'm regulating commerce, preventing guns at schools. That's not really a commerce action. It's a safety action, and it's good, but that's for states to do. States protect schools. And I'll add another line for your understanding. We often think about the federal government has everything now. But it really doesn't. Many, many trillions of dollars are spent by states, not, with the federal government not necessarily telling them how to spend it. Many millions of employees working at state jobs, state and local jobs, and local, very important there. States police. States provide transportation. States provide education. States provide health care in a lot of cases, welfare. They're helped by the federal government in many ways, and there's court cases around that. But essentially, the 10th Amendment works in silence a lot. This is the way it should be. As one justice says, it's basically a truism. But what we're going to focus on today mostly is those last four words that barely ever get mentioned. What is this? Or the people? Because that's not about states. That's about all of us, right? That's the argument of Elizabeth Ann Reese in her journal article, Popular Sovereignty and the Power to Choose a Government. And she's a scholar that sees an enlarged popular sovereignty, that really there should be the state government, the federal government, and the people. And all are pillars of sovereignty. All of them have a part in this. Now, John Marshall in McCulloch and v. Maryland doesn't just talk about a banker tax. He's really deciding what the Constitution means. And he's saying that in the Articles of Confederation, the powers of the national government, that's the original, the articles of the original document, proposed at the time of the beginning of the Revolution, not actually approved until 4 years into the Revolution, but for a variety of reasons, but still essentially the governing document of the United States from 1780, I should say, until 1789, let's say. Powers to the national government are expressly delegated. It doesn't say that in the 10th Amendment. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. It doesn't say expressly delegated. It says the powers not delegated. So he's saying there can be other powers the federal government has. They can be implied. And the rest of the language of the Constitution doesn't survive unless you can do some basic things. And if they wanted it to be so rigid, they would have said expressly. Here's what Elizabeth Reese says. To protect state sovereignty, contemporary textualism has reinvigorated the 10th Amendment as a judicially enforceable limit on federal powers. However, she's saying, they're missing something. In casting the 10th Amendment as the states' rights amendment, these textualists have inexplicably glossed over, she says, a piece of text. The final four words, which reserve powers to the people. Primarily, the 10th Amendment protects that power, which is at the heart of popular sovereignty. The power of the people to choose their government. The 10th Amendment ought to protect popular sovereignty, as it protects state sovereignty, by serving as a source for robust judicial review of federal and state laws that infringe on popular sovereignty. Recognizing this overlooked portion of the 10th Amendment could alter current legal doctrine, particularly those, she says, surrounding voting rights by treating fair, free, and accessible elections as a matter of competing sovereign powers, rather than individual voting rights. Where, I ask, she says, have the people gone, and what has become of their powers? So, let me, again, reading the 10th Amendment again and give what I believe her perspective on it. The powers not delegated to the United States by the Constitution, no prohibited by it to the states, are reserved to the states respectively or to the people. She believes this is unmistakable. They didn't have to add those four words. And it's like to or to the people. So the people are there with some powers. And in the, where I really do find this argument to be convincing is particularly in something like voting rights. The kind of supra-government actions, like the ability to choose the government, Why should I have to argue with a state over how I choose you? It has to be the easiest method for me to vote. It has to be very easy. States should be making it easy to participate, not bringing up roadblocks. But it's not just about voting. It could be about much more. There are some who believe that if you look at the people or to the people as voting a reference, that there's this other pillar, the federal, the state, the people. But this is the argument against that. The people are too big. Isn't this the problem we have if you don't like populism, either if you don't like the left populism or if you don't like the right populism? The reason you don't is because you're thinking they're just kind of whooping people up and getting them to act. And then we make bad decisions because what is the people? There's too many. There's 330 million. How do you really determine what they're all thinking at once? So all we're getting is a series of constantly changing decisions. There'll be no order and complete chaos. That's a great argument. But if you think about more fundamental things that all people would want, and, I have to go to voting, I could think of something like parental rights. Not nowhere in the Constitution expressly says it. Right to travel between states that are part of the United States. Like, shouldn't be blocking me from going into Pennsylvania just because I'm from Connecticut, right? On those matters, you see the people. But a lot of other things are delegated. Here's Elizabeth Reese again. The founders themselves had different views of what role the people should have in their government, or what role the Constitution's text, in fact, gave them. In the moment of its conception, a diverse group of brilliant legal thinkers weren't able to interpret these words as having any common understanding. As such, originalism as a reason to discredit the substantive reservation of power in the people is at best one of several competing arguments amongst the scholars who have specialized in the origins of America's Constitution and its continued relevance to constitutional interpretation. We might be left with an unsatisfying answer to the question of the 10th Amendment's original understanding. Like, what were they really thinking when they put it in? But we know this. Our founding is inescapably a story about the consent of the governed. Even if some of the Federalist framers had hoped that the structure of their government would circumvent the will of the people, they would undoubtedly be disappointed. The people were either convinced to ratify, or at least did not again rebel to overthrow the Constitution because of a grand and effective piece of rhetoric employed by the Federalists. And that's in those Federalist Papers and everywhere else. Popular sovereignty, the people rule in this system, and that preamble to the Constitution. Even if some of the founders didn't like the people, even if they were anti-populist, anti-democratic, I can certainly say that about a lot of the Federalists. The founding narrative is still democratic and dependent on the power. In other words, what Elizabeth Reese argues makes a lot of sense, even if they lied. And she doesn't think they did. They put the weight on the consent of the governed and enshrine popular sovereignty and democracy as the value that has won the day. I want to address something different. So what we're saying here is these last four words of the 10th Amendment invoke the people, separate from the states. And here's the reason why. The word or comes from Old English, Proto-Germanic, as near as we can tell. Oath the, meaning either, otherwise, choices. This or that. Alternatives. Two alternative routes to a power that must be respected. States, people. States, people. We know Reese's argument. You can see I'm bite into it. I really think that she's on to something and that we're losing something with the current court cases that focus on states only. I do want to talk about Justice Thomas and one of his dissents. He disagreed in a court case where the court made a suggestion that the people of the United States should be used rather than the people of the several states. in interpreting the 10th Amendment, meaning that instead of the people of the several states are the only true source of power, meaning the people of the several states are the only true source of power. There is no people of the United States. There are 50 states right now, and those states are sovereign. Those states that are full of people are sovereign. The last phrase of the 10th Amendment to Justice Thomas is nothing more than a careful decision by the founders not to take a side on the distribution of powers between the people of the states and their governments. But courts must read this as it's the states.
K-pop Demon Hunters Haja Boys breakfast meal and Huntrix meal have just dropped at McDonald's. They're calling this a battle for the fans. What do you say to that, Rumi?
It's not a battle. So glad the Saja Boys could take breakfast and give our meal the rest of the day.
It is an honor to share.
No, it's our honor.
It is our larger honor.
No, really. Stop.
You can really feel the respect in this battle. Pick a meal to pick a side.
Ba-da-ba-ba-ba.
At participating McDonald's while supplies last.
And sure, if there's a problem and some dictator has taken over I'm going beyond what Thomas said. A dictator has taken over the state of Arkansas. Who knows? Maybe. No comment. There's another clause. The Republican government that each person in the United States is promised comes to play there. And the U.S. has to shut that down. That's not the normal functioning of government. But if the 50 states are functioning normally, right, they're not violating, say, the 14th Amendment, he says, or to the people, merely refers to all those people living in Arkansas. They elect a state legislature, state senators, elect a governor, they pass laws, and that's how they participate in the republic, through their state. Through participation in state governments, the people determine which reserved powers their state government may exercise. If you don't want them building roads, right? If you don't want them to build too many schools, that's what you do when you participate in state government. When you yell at your state legislator, don't yell at your state's legislator. I have a friend who's a state assemblyman in New Jersey. I mean, don't yell at them. But anyway, that's how you participate in democracy. And that's it. The popular sovereignty recognized by the 10th Amendment was the sovereignty of the people of the states, to then further empower their state governments. Now, says one legal scholar, Akil Amar, but how could this be? Because the people, it's in other parts of the Constitution. So the people in the 10th Amendment, are they different people from the preamble and the 9th Amendment, which reserves powers to the people? Let's look at another case, and that is United States versus Comstock. It has to do with the federal government prison system. A small group of prisoners, sex offenders, who have finished their sentences, but they're considered mentally ill. They're considered dangerous. Congress passed a law allowing the federal government to keep them confined. The case reaches the court, United States versus Comstock. Justice Stephen Breyer, writing for the majority, looks to John Marshall's case. He doesn't deny that all of this looks very much like prisons, mentally ill, like very much like state territory stuff. But he reframes the question. The Constitution gives Congress certain powers, and under the necessary and proper cause, it also gives Congress the ability to carry those powers out. That's what Marshall argued. If the federal government runs a prison system, then you don't just let them run the building and say, can't do anything else. They need to run all aspects of that. And part of it is managing dangerous individuals within that system, even after their sentence. It can be seen as part of that broader responsibility. I'm sure if we go too far, if they went too far with it, Breyer would be willing to smack them down, but not in the context of the recent prisoners, and we're determining what to do with them. Federal government territory. Court says the power of the federal government are not limited to what's expressly written down. So this is like a 21st century restatement of John Marshall's decision. They include implied powers. But once you accept that, the 10th Amendment looks a little different. It doesn't reserve everything not spelled out to the states. It reserves what's left after you account for both enumerated powers and those implied by them. So when critics say the law invades state sovereignty, the court responds, not necessarily. Some overlap is going to happen. That's a very Breyer way of thinking, by the way, but it's, federal power, when legitimately exercises, it's the same place. Remember, we talked about before. The federal government had a branch in Maryland. The federal government has a base in Arkansas. It can reach into areas where the states also exercise. And guess what? We too. You're a citizen of a state, perhaps territory. If you're American, you're also a citizen of the United States. It's not a hard wall, Breyer's thinking. It's a boundary that has to be worked out in practice and with conditions. If the 10th Amendment were read strictly, only what is expressly listed goes to the federal government. Most authority would then go to the states. And then people like the popular sovereigntists, or people like Reese, somewhere in the middle there, would have to battle it out with people like Clarence Thomas to see whether that goes to states or people. But they want most of the power, except for a limited list of things that are in the Constitution expressly that the federal government can do. So it's interesting, those last four words of the 10th Amendment could be read to give a stake in that debate if that debate ever comes again. But right now, we still have a pretty expansive implied powers doctrine of federal authority, and doesn't seem to be going away anytime soon. The court currently treats it as part of a balancing act. State interests, yes. The people's interests, but also what coexists in the national government. Okay. Looking at my list, we talked about Thomas, we talked about the bank, we talked about Comstock, we talked about the word or. Now let's talk about this last four words of the 10th Amendment and in regards to the rest of them. Here's Reese again. States' rights became the battle cry of slavery, and then segregation, and most recently the movement against LGBTQ equality. It's only recently we're hearing more from the left say about states' rights, particularly that most recent Minnesota case, but also say in Maine against attack from the federal government, or their perceived attack, whatever you want to say. Popular sovereignty is the rhetoric used by discriminatory states while they're doing it. It's surely, Reese says, a gross perversion of popular sovereignty and a contradiction to use it as a vehicle to refuse to include all kinds of people as equal members of the electorate. As President Lincoln observed, nearly 80 years ago, we began by declaring that all men are created equal. But now, from that beginning, we have run down to the other declaration, that for some men to enslave others is a sacred right of self-government. These principles cannot stand together. They are as opposite as God and Mammon, and whoever holds to the one must despise the other. The 10th cannot be a sword, Reese says, used by discriminatory state governments. So those last four words, or to the people, in the 10th Amendment, must mean something. I mean, the basic rule of constitutional interpretation is the words written are there for a reason. Or to the people. Be very suspicious for reading words out, or to the people. You could have had a period there instead of a comma, or to the people. But one could say, yeah, but it's like the whole 10th Amendment and the 9th Amendment. They're maps, they're guides for judges in the future. They're reminders of truisms, reminders of our first principles. It's the people. And maybe there's a thing that a state doesn't do, right? But it's reserved to the people. But it doesn't say are reserved to the states, then to the people. It says or to the people, meaning could be either or. And a lot of this we just simply don't know because or to the people hasn't traditionally been used as a way to make judicial decisions. That could happen in the future. I think voting rights is an excellent place to do it, because if I say, again, like let's look at it this way. Sally, here's $5. You can go to the store, either have an ice cream soda or buy candy. We're just using or, just to get your mind into it. You could do either one is valid. If she goes to the store and buys ice cream soda, that's okay. Goes to the store and buys candy, that's okay. That's why you have the or. Here, same thing. You reserve a power to the states, you're in line with the 10th Amendment. You're following the roadmap right. If you reserve a power to the people, you're in line with the 10th Amendment. You're following it right. The federal government does not have a right to limit how people vote. Where is that protection coming from? Justice Thomas might argue from the states. I mean, he probably wouldn't argue it at all, because he'd say, well, that's just another part of the Constitution. But where's the base power that's coming from? It's not coming from states. That's the base power, is the delegation of the people, the people's rights. And voting really hits it there. You don't have... the right to vote is not something reserved to states. It's that other or reserved to the people. So I hope you enjoyed this discussion. That's as much as I want to talk about. And, interesting times. And we'll see what happens with all of this.
Ready to transform your career in real time from where you are? Brown University's flexible online master's programs will help expand your business influence and your network in just 16 months. Choose from management, business analytics, or organizational leadership programs that will prepare you for today's most pressing business challenges without putting your life on hold. Scholarships available. Tap to learn more.